Imagine this. A man named in no records will share, just a picture in your mind. He's 68, healthy as far as anyone knew, married for 41 years, with 3 grown kids and a house he paid off a decade ago. He always meant to get a will done. He'd talk about it at Thanksgiving, half joking, "I'll get to it." Then one ordinary Tuesday, he doesn't wake up, and in the weeks that follow, his wife, the woman who raised those kids with him, who has been at his side for 4 decades, finds out she does not automatically get to keep everything. Depending on the state they live in, she might have to share the house, the bank accounts, even his pickup truck, with his children. Not because anyone wanted that, not because he didn't love her enough to provide for her, but because he never wrote down what he wanted, and so the state wrote it down for him. That's the part most people don't understand about dying without a will. It doesn't mean nothing happens to your stuff. It means a set of laws you've probably never read, called intestacy laws, step in and make every decision for you. Who gets the house? Who gets guardianship of your kids if they're minors? Who's even allowed to manage your affairs while the court sorts it all out? And in almost every case, the outcome is messier, slower, and more expensive than anything you would have chosen yourself, if you'd just taken an afternoon to write it down. So today we're going to walk through exactly what happens, step by step, when someone dies without a will in the United States. Not in vague terms, but the real mechanics, who actually inherits, how the courts get involved, what it costs your family in time and money, and the surprising ways even simple estates turn complicated. By the end, you'll understand why this is one of those things that feels optional right up until the day it absolutely isn't. Before we go further, I want to be upfront about something. I'm not an attorney, and nothing in this video is legal advice. I'm an educator who researches these topics, so I can explain them to you in plain English, the way I'd explain them to my own family at the kitchen table. Estate law is not the same in every state. In fact, the rules we're about to walk through can shift meaningfully depending on where you live, especially in community property states versus everywhere else. So think of this as a map that shows you the terrain, not turn-by-turn directions for your exact address. For that, you'll want to sit down with a licensed estate planning attorney in your state, which we'll talk more about toward the end. Here's why this matters right now, today, whether you're 45 or 75. Roughly 2 out of 3 American adults don't have an updated will. Not no will ever necessarily, just nothing current, nothing that reflects their actual life, their actual family, their actual wishes. And the thing about death is that it doesn't wait for a convenient time. It doesn't check whether you got around to it. The people most affected by this aren't the ones who pass away. It's the ones left behind, the spouse, the kids, the siblings, who suddenly have to navigate a legal process at the worst possible emotional moment of their lives, often not even understanding why it's taking so long or costing so much. So here's what we're going to cover. First, we'll talk about exactly what dying intestate means, and how the state decides who inherits when you haven't. Then we'll walk through a real-feeling example, so you can see how this plays out for an actual family, not just in the abstract. After that, we'll get into probate, the court process your family will have to go through, why it takes so long, and what it actually costs. Then we'll cover some of the most damaging myths people believe about this topic, the kind that lead families into situations they never saw coming. And we'll close with practical steps you can take, starting this week, to make sure your family isn't the one we're talking about in a video like this next year. If any of this feels useful, consider subscribing. We cover these real-life estate and retirement topics every week, and I promise to keep explaining them in plain English, not legal jargon. Let's start with the basics. When someone dies without a valid will, the law calls that dying intestate, and every state has what's called an intestacy statute, essentially a default inheritance plan that the state applies to your assets when you haven't made your own plan. Think of it like this. The state assumes it knows roughly what a typical family would want, and it applies that formula to everyone, regardless of your actual relationships, your actual wishes, or anything unique about your situation. In most states, if you're married with no kids, the surviving spouse typically inherits everything, or close to it. But the moment you add children into the picture, the formula gets more complicated, and this is where people get genuinely surprised. In many states, if you're married and have kids with that spouse, your spouse might only get a portion of the estate, sometimes the first chunk of money plus half of what's left, while your children split the rest. If you have kids from a previous relationship, it gets even more layered, because the formula often treats those children the same as the children from your current marriage, which can mean your current spouse ends up sharing the estate with kids who aren't theirs. None of this is because the law is trying to be unfair. It's just a generic formula, applied the same way to millions of completely different families, with no ability to account for your specific wishes. And it's not only about money. If you have minor children and both parents pass away, or if you're a single parent, a court decides who becomes the legal guardian of your children if you haven't documented your wishes. Maybe you'd want your sister to raise them. Maybe you'd absolutely not want a certain relative involved. Without a will naming a guardian, that decision goes to a judge who is doing their best with limited information, often choosing between family members who may disagree, sometimes even litigate over who should raise your kids. That's not a hypothetical detail. That's one of the most emotionally significant pieces of this whole conversation. There's also the question of unmarried partners. If you live with a partner for 20 years, but you're never legally married, and you die without a will, in most states that partner inherits nothing automatically, no matter how long you were together, no matter how intertwined your lives were. The law generally only recognizes legal relationships, spouses, children, parents, siblings, not relationships based on commitment or time spent together. This catches people off guard constantly, especially in long-term relationships, where marriage just never happened to come up. Let's make this concrete with an illustrative example, a composite, not a real family, but a situation built from patterns that show up again and again. Imagine a woman in her early 60s, remarried for about 12 years, with 2 adult children from her first marriage, and a warm relationship with her second husband's grown children, though she never formally adopted them. She owns the home she lives in with her husband, but the house is titled only in her name from before the marriage. She passes away suddenly, without a will. In many states, her husband does not automatically inherit the full house. Instead, her biological children may be entitled to a significant share of that property alongside him. Suddenly, her husband, who has lived in that home for over a decade, may need to negotiate with his stepchildren just to continue living there, or potentially even sell the home to satisfy their inheritance share. His stepchildren, the ones he helped raise, who call him a father figure, get nothing automatically, because intestacy law only recognizes biological or legally adopted relationships, not emotional ones. This is the kind of outcome nobody intends. Nobody sits down and decides, I want my husband fighting my kids over the house, and I want to leave my stepchildren out entirely. It happens simply because no one wrote anything down, and the default formula doesn't know the difference between love and biology. Now let's talk about what your family actually has to go through to sort all this out, because this is where the real-world pain shows up. When someone dies, whether they had a will or not, most estates have to go through probate, which is the court-supervised process of identifying assets, paying debts, and distributing what's left to the legal heirs. When there's a will, probate is usually faster, because the will names an executor and spells out who gets what, which the court mostly just needs to confirm. When there's no will, probate tends to take longer and cost more, because the court has to do extra work, appointing someone to administer the estate, called an administrator, often after notifying every possible heir and giving them a chance to weigh in or contest who that administrator should be. This process can take anywhere from several months to well over a year, sometimes multiple years for more complicated estates, especially if family members disagree about who should be in charge or how assets should be divided. During that time, certain assets may be frozen, bank accounts can be locked, property can't always be sold or refinanced, bills still need to get paid, but the people who'd normally have authority to pay them might not yet have legal authority to act, because the court hasn't formally appointed anyone yet. Meanwhile, attorneys' fees, court filing fees, and administrative costs are typically paid out of the estate itself, meaning less money eventually reaches the heirs. Depending on the size and complexity of the estate, these costs can run from a few $1,000s into the tens of thousands, money that would otherwise have gone directly to the family. And here's something people rarely think about. Probate is a matter of public record in most states. That means the inventory of someone's assets, their debts, and who's inheriting what becomes a document anyone can technically look up at the courthouse. For families who value privacy, that alone is uncomfortable. Estate planning tools like a properly funded revocable living trust can sometimes help assets pass outside of probate entirely. But that's a separate topic, and again, whether that's the right tool for your situation is something to discuss with an attorney in your state, not something to copy from a video. Let's bust a few myths, because misinformation in this space causes real damage. Myth number 1. If I'm married, my spouse automatically gets everything, so I don't need a will. As we covered, that's only true in some states and only in certain family situations, usually only when there are no children involved or in certain community property states. The moment children, stepchildren, or prior marriages enter the picture, that assumption often falls apart. Myth number 2. My estate is too small to worry about this. People often picture probate and intestacy as problems only for the wealthy. In reality, even a modest house, a car, a retirement account, and some savings can trigger a lengthy probate process. The size of the estate affects how much money is at stake, not whether the legal process applies to you. Myth number 3. If something happens, my family will just figure it out together. Families often assume that love and good intentions will smooth over the legal gaps. But intestacy law doesn't ask your family what they've agreed to informally. It applies a rigid formula regardless of any verbal agreements or handshake understandings you may have had. Even close, loving families can end up in real disputes, not because they don't get along, but because the legal process forces decisions that nobody discussed in advance. Myth number 4. A will is only about money. As we touched on with guardianship, a will can also name who raises your minor children, who manages a special needs family member's inheritance, who you want as your executor, instead of leaving that decision to a court, and even instructions around things like pet care. Reducing it to just about money undersells what's actually at stake. Myth number 5. I'm too young for this to matter. Death and incapacity don't check ID. Car accidents, sudden medical events, and unexpected illnesses affect people of every age. The earlier you have a basic plan in place, especially once you have a spouse, children, or property, the less your family has to navigate a legal maze during one of the hardest moments of their lives. So what should you actually do with this information? Start by taking an honest inventory of what you own: your home, retirement accounts, life insurance policies, bank accounts, vehicles, and any other significant property. Then think through, in plain terms, who you'd want to inherit each of those things, who you'd trust to manage your affairs as an executor, and if you have minor children, who you'd want to raise them if both parents were gone. Write these thoughts down, even informally, because that becomes the foundation for a conversation with an attorney, rather than starting from a blank page. From there, the practical next step is scheduling time with a licensed estate planning attorney in your state. Many offer initial consultations at a reasonable cost, and a basic will, along with documents like a durable power of attorney and a healthcare directive, is often far less expensive than people assume, especially compared to the cost of probate litigation down the road. If you've recently married, divorced, had a child, bought a home, or experienced any major life change, that's also a natural trigger to update an existing will, since outdated documents can sometimes cause nearly as much confusion as having none at all. And if you're a parent of minor children, naming a guardian in your will isn't optional in the sense of importance. It may be the single most protective thing you do for them in this whole process. I want to bring this back to where we started. None of this is really about paperwork. It's about the people you love. It's about making sure your spouse isn't forced to negotiate with your children over the house you built a life in together. It's about making sure your kids know exactly who's going to take care of them if the unthinkable happens. It's about sparing the people you care about from spending a year of their grief tangled up in a courthouse, paying fees, waiting on a judge, instead of simply being together and healing. A will doesn't prevent loss, nothing can do that. But it can prevent the loss from being compounded by confusion, conflict, and cost, at the exact moment your family can least afford any of that. So if you've been putting this off, and most of us have at some point, let this be the nudge. You don't need everything figured out today, you just need to take the first step, whether that's writing down your wishes on paper this week, or calling an attorney's office to put a consultation on the calendar. Future you, and more importantly, your family, will be grateful you didn't wait for a more convenient time, because that time doesn't actually exist. Before you go, a reminder. Everything in this video is general education, not legal advice. Estate laws vary significantly from state to state, especially around intestacy formulas, spousal rights, and probate procedures, so nothing here should be treated as instructions for your specific situation. Before you make any decisions about a will, a trust, or how your estate should be handled, please talk to a licensed estate planning attorney in your state. If this video helped you understand something you'd never had explained clearly before, consider subscribing and share it with someone in your life who's been meaning to get their will done. It might be exactly the nudge they need too.